Hi, this is Curt, and welcome to another edition of File Law Roundup.
Okay, let's go to Chicago. Not for pizza necessarily, but let's go there. So Chicago is a really complicated suit. I'm trying to make it interesting or easy. It is interesting, but easy. So it's complicated, but I think I have a higher, view of this to make it a little bit easier. Obviously, the details of the testing, which we'll talk about, are on your site. But so 12 African-American fire lieutenants with Chicago Fire Department have sued. They claim they're discriminated against in a captain's exam based on their race. And they claim that the method of scoring is what discriminated is the basis for discrimination. Now, interestingly, there's repeated references, as we'll get into this, to the violation of certain sections of, I believe, the CBA, right? The agreement. And they say that so I'm not quite sure why that's discrimination alone, because you violated contract. Breach of contract is a breach of contract claim, much simpler than, frankly, discrimination claim, right? Words on paper are easier than discriminatory intent to prove.
I can explain that one.
Good, please.
Yeah. Because if the resolution or the solution to a breach of contract in a collective bargaining environment is a grievance, and the union owns the grievance.
Okay. So you think the union didn't want to pursue it?
Well, I don't know if they did or didn't, but if you're an individual who's being discriminated against, you don't want to have to go to the union, and then you have to have the union's attorney handle it, and they get to settle it and all that. Whereas when you allege race discrimination yourself, Title VII violation. Now, whether or not that'll be a defense for the city and say, now, wait a minute. We have a collective bargaining agreement. This should have went to arbitration. So,
okay,
so it does affect other people. That's why you have collective bargaining, because if they prevail, other people are not going to get promotions, and that's one of the reasons why you have a collective bargaining agreement, is so that those things can be worked out collectively, and not this person wants it done this way, this person wants it done a different way. So
right. So I think it's first, if you're going to be one of those people, right, you've got to determine, am I going left or right, union or private? So here, and look, the scoring is complicated, but basically what they said is that the scoring process had an adverse impact on African Americans compared to Caucasians or non-African Americans. And they brought it to the city's attention. And they allege in the complaint that the city, again, this is just the lawsuit. There's no decision. This is early on, right? Where you catch these things right at the beginning. But they allege that the city could have corrected this by taking one of a number of actions, but they didn't. And basically what you have is you have weighting of written, oral, and seniority scores. Now, I thought when I started this, we were going to see seniority being the place that there was discrimination, right? Because usually you could say, well, wait a minute, seniority, well, you gave seniority and there's more Caucasians who are higher up the chain, so they got more points or something. Or the more Caucasians have been employed longer, but who knows? But that's not what it is. And Chicago, correct me if I'm wrong, is not under a mandate to equalize their the population of African Americans in the department,
it's
right?
Funny, you and I, we cover so many cases, Brad, that it's hard. And believe it or not, you and I covered this. I'm just looking at it. June 27, 2022, we covered this.
Okay.
And they dissolved the consent decree.
There you go.
Okay. So there you go. So,
but that really wasn't the main issue here. So here they allege that, which is interesting, that the method of scoring did not comply with the CBA. So that, if it's proven, does assist in saying, why did they breach the CBA, right? And so that might make out a prima facie or on its face case of discriminatory intent, because they had what they were supposed to do and they didn't do it. And now the burden may shift to say, why did you violate these sections if you did it all? So effectively, they're going to start with did you breach the contract? Right? Or were you allowed to? If you just followed the contract, there's no discrimination, right? The union adopted it. So here, basically what they're saying is that on this 2017 promotional exam, there was a curve applied to various aspects of this exam, and the curve didn't favor the African Americans. And they gave different weight based on oral and, you know, and different categories. And the way this is what I found was weird. So they gave more weight to a more correct answer. Now that to me seems crazy. It's a correct or more correct is, and I'm not an expert on testing, right? And very complicated.
PhD in education, research and methods, right?
Yeah, but this seems crazy. It's if the answer is correct, the most correct answer, you know, it's you're right, but you're more right. That doesn't make sense. But they gave like 30 times the number of points, 30 points for the most correct and 1 point for the least correct. And I'm gonna raise a question to you, and then they unevenly weighted it, right? So, okay, you gave the better answer, but here's my question. How is that race discrimination? Everybody was free to give the most correct answer. How does the weighting affect on that? And that's the main part of their suit. I really thought they were going to go with seniority, but that's the main part of their suit.
Yeah, it has to do with the 80% rule. And that's at the end of the day, we don't even look at whether or not a particular question could have had an impact. We don't even look at that. What they look at, whoever is looking at it, they look at, does the actual hiring burden the minority group in a way that's they're not at least 80% of what the majority group scored. So if African Americans score, if Caucasians score, let's just say 100, and the average score for African Americans is 75, that it is presumptively and rebuttably, but it's presumptively discriminatory because it's not 80% of what the majority group gets. So I think at the end of the day, they're saying that the test was flawed. Okay, but I think the more interesting issue now is what's the resolution, and what they proposed was by changing what you were talking about, by changing those scoring matrices, then you would get to a point where you eliminate that discrepancy. And that's what they're suggesting. And they pointed it out to the city, and the city said, yeah, but we're not going to do that. Or at least according to the complaint.
Yeah, and who knows what the request really was, what their answer really was, but it's all going to come out in the wash. So we'll figure it out.
It is.
The brutal part to all of these types of cases, as you know, they go on for years. People are holding the position of lieutenant who may be removed. Then there's back pay. If there's a victory, you get back pay. The people who are lieutenants lose their time or not. I mean, there's all that. And that's, God, there was a suit so long ago where, maybe you'll know it off the top of your head. It must have been like 5 years ago, but where the lieutenants or whoever were removed, right? And then came the captain promotional test, and the lieutenants wanted their time counted. And everybody else says there's a further exacerbation of discriminatory intent because they shouldn't have been in that position. And now we only get a year as lieutenant. You're crediting them with 12 years to a position they never should have had. And I thought that case, I don't remember so long ago.
There's not one case. There's a bunch of them.
Many cases like, okay.
Right. And what happens also is the plaintiffs will go into court and they'll ask the court for an injunction to block promotions because they don't want to see that happen. Because if you don't make lieutenant when you're supposed to, then you're not going to be eligible for captain. And if you don't make captain when you're supposed to, you're not going to make battalion and right on up the line. So what they say, this is what they go into court and say, we want a temporary restraining order, we want a preliminary injunction right now, blocking any further promotions, which sounds reasonable.
Except the city comes back and says, wait a minute, that's a safety issue. We need people in the front seat who are qualified.
Departments, I think it was Cincinnati, but there's been a number of departments across the country that have gone 6, 8, 10 years with no promotions. Okay. And again, to a judge who doesn't really understand the fire service and has what appears to be meritorious claims on the one side, and they'll say, oh yeah, okay, so we're going to block promotions temporarily. And then the case, as you pointed out before, the case drags on 6 years, 8 years, 10 years, goes to appeal, comes back down, and there's no promotions. And now you do have that. Even a year, you can have that safety problem. Okay, so I don't know if you can avoid these. I look at a lawsuit like a Mayday. Okay, we can become very good at handling a Mayday, but at the end of the day, we're so much better off avoiding the Mayday if we can possibly figure out how to avoid it. And it's the same thing here with the lawsuits. And I don't mean roll over on every claim, but at some point we've got to figure out a way to avoid the lawsuit.